Hello and welcome to an episode that talks about the law of sedition. I am Sakshi Mandwal and today's subject expert is Ms. Swati Singh, a media professional for the last 15 years, specialized in mass communication. She has worked as a journalist with Hindustan Times, Indian Express, Career Launchers, etc., and has also taught print and electronic media in various universities and colleges, including the Delhi University. Today, we shall be discussing the law of sedition. It is a very controversial law which, according to some thinkers and theorists, exists as a threat to freedom of speech and expression. Let's start by discussing the objectives of this episode. The objectives of the lesson include to understand the meaning of sedition, to understand the significance of the law of sedition, to trace the history of the law of sedition, to learn about the constitutional validity of sedition, to discuss the stark issues between sedition versus freedom of speech and expression, to learn and do a comparative analysis of sedition of India versus other countries, to discuss the problems related to sedition. So, let us start by asking, what is sedition? Section 124A of the IPC, which deals with sedition, states, whoever, words either spoken or written or by signs or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Section 124A of the Indian Penal Code, which deals with sedition, was drafted by Thomas Babington Macaulay and included in the IPC in 1870. The Sedition Law of India, which was introduced at the time when India was under foreign rule. Therefore, the laws during that time were formulated to deprive the citizens of India of their rights so that they can rule over them and expand their colony. On the other hand, freedom of speech and expression is a basic human right that was put within the ambit of fundamental right under Article 19(1)(a) of the Indian Constitution after the independence of the country. The sole aim was to provide the rights to the citizens which was taken away by the foreign rulers. This was the past scenario when all these rights were being formulated in the country. Presently, there are various cases where sedition and freedom of expression counter each other. Citizens are prevented from expressing their views against the government in power, executive, judiciary, etc., in the name of the law of sedition. Some prominent cases under this law are M.K. Gandhi and Sri Shankar Lal Gelaba were held guilty of sedition for causing hatred against the British government in 1922 before the Session Judge of Ahmedabad. Pandit Jawaharlal Nehru addressed a mass assembly of peasants at Allahabad in 1930 and started a non-tax campaign. He was arrested for the offence of sedition. Now we move on to learn about the relevance of Section 124A. The sedition law has been a very controversial topic in India. There have been calls for restricting the sedition law from the statute, some others advocating for retaining the law but keeping its implementation within defined legal limits. This would help us to understand as to how to strike a balance between fundamental rights and national security. The punishments which come along with sedition law varies from imprisonment up to 3 years to a life term and fine. A person charged under this law can't apply for a government job. They have to live without their passport and must present themselves in the court as and when required. Recently, the debate regarding the sedition law has again reignited due to the recent order passed by the Supreme Court in MS Amora Broadcasting Company Private Limited and ANR versus the state of Andhra Pradesh and ORS 2021, and the judgment for quashing an FIR in Vinod Dua versus Union of India and ORS 2020. The Supreme Court has made efforts to re-examine the validity of the colonial-era sedition law in the writ petition filed by journalists Kishore Chandra Wang Kemcha and Kanhaiya Lal Shukla, challenging the validity of sedition law as violative of freedom of speech and expression. History of the law of sedition in India. Many legal experts argue that the sedition clause is a mark of British colonial rule, which was originally introduced to overpower critical voices emanating from the Indian freedom movement. Section 124A of the Indian Penal Code 1860, as we have today, was absent from the original draft of Macaulay's IPC in 1860 and was only introduced in the year 1870, piloted by James Stephen. This version went through further modification through the IPC Amendment Act 1898, since when it has largely retained its form. The first notable case for the offence of sedition was reported in 1891 in the case of Queen Empress versus Jogendra Chandra Bose and ORS. In this case, the editors of a Bengali magazine were charged for their criticism of the British government's policies, specifically regarding the age of Consent Act 1891. The publishers contended that the felony of sedition only penalized writing of seditious content and not the publication thereof, and also challenged the existence of the sedition law itself. They also contended that penalizing people for exercising their rights went against the original intent of the law. The Calcutta High Court held that the publishers could not be forgiven of legal liability simply because they had not written the seditious content. The reason was that the circulation of the magazine by them was intended to be read by the targeted audience. The High Court had also emphasized upon the distinction between the terms disapprobation, that is genuine criticism, and disaffection, which refers to any feeling dissimilar to affection. The court thereby concluded that since only disaffection is penalized, the offence of sedition does not take people's rights away. In another historic case of Queen versus Bal Gangadhar Tilak and Keshav Mahadev Bal in 1897, Tilak wrote two articles, Shivaji's Utterances. Tilak and C.G. Bhanu, a notable Pune intellectual, spoke on this article at the Shivaji festival. The Bombay government claimed that through the speech they incited disaffection that led to the killing of two British officials. The Bombay High Court stated that it is the question of whether these articles can be considered as inciting disaffection against the government and has nothing to do with the case. Thus, it merely reduced the interpretation of the legal text to incitement of feelings of disaffection. However, after the perusal of the article, it was observed that it illuminated the political ideology of Tilak as he stood at the radical side of liberalism. The High Court accepted the definition propounded in the Jogendra Chandra Bose about the word disaffection and discoursed that bad feeling against the government is criminal. They also held that it is immaterial whether there were any consequences. The intention of the offender is the primacy for qualifying for the offence of sedition. In 1948, K.M. Munshi moved an amendment to drop the word sedition from the Constitution draft, and eventually it was removed from the Constitution after discussions of the Constituent Assembly. After independence in Tara Singh Gopi Chand versus the state 1950, the Punjab High Court recognized that Section 124A undeniably restricts freedom of speech and expression under Article 19 of the Constitution. Thus, it invalidated the section. However, the Constitution, First Amendment Act 1951, reimposed the controversial law. The law was not only reimposed but was strengthened by the adding of two words, friendly relations with a foreign state, public order, and incitement to an offence as grounds for imposing reasonable restrictions on freedom of speech. Initially, the Constitution only contained the state's security, defamation, contempt of courts, and decency and morality as grounds for restricting speech. It was during the Indira Gandhi government the offence of sedition under Section 124A was made a cognizable offence for the first time in India's history. The new Code of Criminal Procedure 1973, replacing the old version, sedition can be considered as cognizable offence, authorizing the police to arrest the suspect without any warrant. Further, in the landmark judgment, Kedar Nath Singh, 1962, the Supreme Court upheld the validity of Section 124A of IPC. It held that the purpose of the sedition law is to prevent the government established by the law from being subverted. As for the stability of the government, its smooth, continuous existence is an essential condition. It also defined the scope of Section 124A and held that to invoke the clause of sedition, there needs to be a pernicious tendency to incite violence. Thus, only those words that intend to disturb law and order or incite violence are held as seditious. Problems with sedition law. The law should be utilized where there is a severe threat to the security and sovereignty of the country. However, the law is used to suppress free speech and weaponized as a tool against political rivalry. It is a de facto strategy for many ruling governments for years whenever they encountered public criticism and protests. There has been an increase in sedition charges. Since 2010, 10,938 Indians have been accused of sedition in 816 cases, reported by Article 14, a media and research group. One can witness that sedition charges come out clearly during significant events opposing the action of the government. According to the National Crime Records Bureau, there has been an increase in sedition cases by 160%. However, the conviction rate dropped to 3.3% in 2019 from 33.3% in 2016. Thus, this shows that the state authorities are misusing the sedition law and they are trying to silence any criticism or dissent against the majority government. Feigned interpretation of the law. The definition of sedition law is ambiguous. The terms mentioned, such as bring into hatred or contempt or attempt to excite disaffection, have the potential to be interpreted in many different ways. Thus, it is argued that this law has the capacity to empower the government authorities to harass innocent citizens who are trying to raise their voices. There is no specific definition, and what activities are regarded as seditious is not defined. Thus, it provides a broad outline. It's time to discuss a debate on sedition, not a ground of reasonable restriction. A committee on fundamental rights headed by Sardar Vallabhbhai Patel. This committee added sedition as one of the grounds on which freedom of speech and expression under Article 19, 1A can be registered. The Constitution provides various fundamental rights to the citizen of India. One of these rights are freedom of speech and expression under Article 19 of the Indian Constitution. This freedom of speech and expression was not absolute and had certain restrictions, and according to the S. Patel Committee, one of those restrictions was sedition and was present in the draft constitution. Various debates and discussions were held not to include sedition as a ground for restriction on freedom of speech and expression. Ultimately, sedition was not included as a reasonable restriction on freedom of speech and expression. Presently, there are 8 grounds of reasonable restriction on the freedom of speech and expression, that is, public order, sovereignty and integrity of the country, contempt of court, incitement to violence, decency and morality, friendly relation with foreign states, defamation. Let us now discuss the constitutional validity of sedition. According to Article 13 of the Indian Constitution, any law, whether enacted before independence or after independence, has to be consistent with fundamental rights. 8. To be constitutionally valid, and any law which is inconsistent with Part 3 of the Indian Constitution will be declared unconstitutional and void. In the case of Kedar Nath Singh versus State of Bihar, the constitutional validity of sedition was challenged. According to the Supreme Court, sedition under the Indian Penal Code is valid, but the interpretation of sedition law will be narrowed down. It is time to acknowledge the stark problem between freedom of speech and sedition. Sedition and freedom of speech cannot go in one line. Therefore, freedom of speech and expression, being a fundamental right, will have an upper hand. But if any person is using this freedom to incite people to violence against the government, then he will be booked under sedition and will be sentenced to 3 years of imprisonment or life imprisonment and fine. The reason behind this is that inciting violence goes against public order, and public order is one of the reasonable restrictions of freedom of speech and expression. And in that case, the constitutional validity of sedition law is intact. Only the interpretation is narrowed down. In the case of Balwant Singh, the Sikh community in Punjab wanted an independent country for Sikhs during the Indira Gandhi government, and they raised slogans like Raj Karega Khalsa and Khalistan Zindabad. Those people who raised such slogans were arrested for sedition. Supreme Court held that slogans won't be deemed as sedition, as people have the freedom of speech and expression unless and until they are inciting people to violence, raise arms, etc. Shreya Singhal versus Union of India is one of the landmark judgment on sedition law. Here the word speech was interpreted in this case by the Supreme Court. Supreme Court stated that through you, spoken or written words can advocate and propagate whatever they want to, but does not incite people to violence. If because of such speeches there is a breakdown of public order and violation of peace and tranquility in the state, then only that person can be booked under sedition. Now we shall be doing a comparative analysis of sedition of India versus other countries, starting with United Kingdom. As a direct rejection of sedition, the UK has terminated the use of sedition law in the year 2009 after the last trial in 1947. According to UK courts, sedition, the law does not reflect the value of modern democracy that the UK follows. Second, the United States of America. Freedom of speech is given extraordinary importance in America. Therefore, some of the laws on sedition have been repealed and some are made inoperative. Courts now provide wide interpretation of free speech and expressions. Third, Malaysia. A very different take on sedition is practiced in Malaysia, where the freedom of speech and expression is guaranteed by the constitution broadly, but still sedition laws are used firmly. Netherlands. On the lines of Malaysia, sedition law exists here, but nevertheless certain precautions related to sedition have not been used since the year 1978. Fifth, Australia. A strict eye is kept on the law of sedition, for since the year 1985, the scope of sedition law has been narrowed down and punishment has also been rendered from imprisonment to fine only. New Zealand. As a bold move, the sedition law was abolished in the year 2007. Civil offences were addressed through the order of criminal law provision. Let us now talk about the fact that why sedition doesn't well with India's law on freedom of speech, of expression. The various reasons marked that propose that freedom of speech and expression do not sit well with sedition include: number one, freedom of press and sedition cannot be balanced. Freedom of the press is a fundamental right guaranteed under Article 19(1)(a) of the Constitution. The state is empowered to restrict free speech under Article 19(2) on the grounds of threat to public order, decency, morality, and the security of the state. Indian jurisprudence makes it clear that citizens' right to free expression and the state's power to restrict it cannot be seen on equal footing. Free expression is a rule and restrictions on it are an exception. The exception cannot be either equal to or more than the rule. Such restrictions should pass the test of reasonableness, as enunciated in several judgments of the Supreme Court spread over decades. Second, mere criticism cannot be sedition. Explanations to section 124A clearly define limits to the law of sedition. It says, comments expressing disapprobation of the measures of the government to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under this section. Comments expressing disapprobation of the administrative or other actions of the government without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under this section. The Supreme Court judgment in Kedar Nath Singh versus State of Bihar 1962 further restricts the scope of sedition law. In the case, the court had read down section 124A of the IPC and held that the application of the provision should be limited to acts involving intention or tendency to create disorder or disturbance of law and order or incitement to violence. Thus, the Kedarnath Singh verdict makes the tendency test imperative for imposing sedition cases on anyone, leave alone the media. Third, logic no longer exists. The Allahabad High Court in 1959 dismissed Section 124A as ultra-biased to the Constitution of India. Unfortunately, the nation lost a golden opportunity to do away with the colonial relic, with the Supreme Court refusing to strike down the section in 1962. Though it has significantly restricted the scope of its use. As early as 2016, the Apex Court reiterated that the Kedarnath Singh verdict should be the guiding principle in the application of sedition law. However, the court has its logic in doing so. Verdict states as follows: it is well settled that if certain provisions of law construed in one way would make them consistent with the Constitution and another interpretation would render them unconstitutional, the court would rule in favor of the former construction. But India's tryst with the sedition law reveals its extensive unconstitutional use, making its repeal necessary. Fourth, dishonor to India. Despite all its limitations, India is a vibrant democracy with a robust media tradition. As former Prime Minister Nehru observed, free press with all its limitations is always better than the controlled press. In countries like the United States, Canada, Australia, United Kingdom, New Zealand, etc., the sedition law is practically defunct or in disuse. On the contrary, sedition law is operational in Saudi Arabia, Turkey, Sudan, Senegal, Iran, Uzbekistan, etc. Sure, every Indian does not aspire to be in the dubious company of the latter set of countries. Fifth, vagueness makes it invalid. Section 124A of IPC is vaguely worded when it says, whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life. The expression disaffection includes disloyalty and all feelings of enmity. As per the Supreme Court verdict in Shreya Singhal versus Union of India 2015, the vagueness of law can be sufficient ground for its invalidation. The US Supreme Court in Grenade versus Rockford said that the vague laws may trap the innocent by not providing fair warning. Such laws trap the innocent citizen or even a policeman, prompting them to file false cases under sedition law. Certainly, Section 124A of IPC is a net so large enough to catch dissenters, dissidents, critics in media, political opposition and civil society representatives who perform the critical adversarial function so crucial for a healthy democracy. Sixth, sedition not part of 19.2. Under the Constitution of India, the fundamental right to free expression can only be subjected to reasonable restrictions specified under Article 19.2, in which sedition is not included. The Constituent Assembly itself unanimously resolved not to include sedition as a ground to restrict free speech. Sedition was initially incorporated under Article 13 of the draft Constitution, which is the equivalent of the present Article 19. At the instance of K.M. Munshi, T.T. Krishnamachari and Seth Govindadas, the Constituent Assembly resolved not to include sedition as an exception to the right to free speech. Seventh, test of causation and proximity. In the case of the Superintendent, Central Prison, Fatehgarh versus Dr. Ram Manohar Lohia, 1960, the Apex Court held that to prevent complete arbitrariness and to give effect to Article 19.2's requirement of reasonableness, there needs to be some test of causation and some understanding of proximity. Indian jurisprudence makes it clear that beyond any reasonable doubt that an arbitrary law is unconstitutional. In Balwant Singh versus State of Punjab in 1995, the Supreme Court has proposed a test of proximity besides that tendency test propounded in the Kedarnath Singh verdict. Even the American Supreme Court held that a clear and imminent danger should be the basis for any restriction of free speech. Eighth, test of national security. As per the Supreme Court verdict in Romesh Thapar versus the State of Madras 1950, nothing less than the endangering the foundations of the state or threatening its overthrow could justify curtailment of the rights to freedom of speech and expression. Thus, if exercise of free speech invokes a proximate and imminent tendency to violently overthrow a government established by law, an action can be initiated under Section 124A of IPC. But in the absence of such a clarity, the law is prone to unconstitutional use. Such a brazen violation of the Constitution warrants the invalidation of sedition law, as the Constitution of India has many provisions to preserve its security, unity, integrity and sovereignty. Time to conclude. Even though there is intact law about sedition and Supreme Court is also clear in its ruling, still the sedition law is seen to be misused by the police in India. There are various examples in this reference related to student protests, etc., and many more cases have been booked under sedition. And therefore, according to Law Commission report, sedition law should be relooked, and there also should be demands for striking down the entire sedition law. In India, many cases of sedition are registered every year, out of which only a few of them can reach the conviction stage. In a recent discussion held between the three-judge bench of the Supreme Court, it was stated that if Section 124A of IPC is found to be violative of Article 19, then it shall be repealed. Also, in a country like India, which follows the principle of modern democracy and which is on the path of being a developed nation, such laws like that of sedition should not prevail. And now it's time for a quick recap. Today we discussed the meaning, need and significance of the law of sedition. We learned that this was a law passed by the British regime to curtail the freedom of speech and expression of Indians. Also, we discussed the various facets of its law and its relevance in the present day. And there are several debates and discussions which put up questions on the usage and existence of the law of sedition. But the truth remains that it is here to stay. Many big leaders of India raised their voice time and again against this law. There are instances where various public movements were curtailed under this law. In other countries, the law has been repealed, even banned. However, whether the law would win or would cease to exist is what we need to wait and watch. That is all that we had for you in this episode. Hope you enjoyed the session and learnt about the aspects of the law of sedition. We shall return with another interesting episode on media and social responsibility. Until then, thank you, farewell and namaste.